This comes a long way from the 6th Parliament, when the then Employment Equity Amendment Bill was passed, and we opposed it from the beginning for the key reason, as Willie has explained, that it will continue to drive unemployment up, economic growth down, and make far more people unemployed and marginalized in our economy than they already are.
From the outside looking in, one might say, oh no, not another fight between the DA and the ANC. From the Bella Act to the Expropriation Act to the VAT increase, there is now a new battleground, and that is the Employment Equity Amendment Act 4 of 2022. So guys, the court case started today, and the DA was at pains to actually explain that they had launched this particular legal action about 2 years ago.
It's an issue that we launched in our court papers more than 2 years ago.
Man, the GNU has been interesting because it's like being in a marriage, but the spouses are taking each other to court, man. The spouses are fighting, but they're saying, we are driving together, we are pushing together to take the country forward, but we're going to do what we have to do if we don't agree.
And we're not flying blind here. We've had an employment equity regime which was meant to drive employment equity for the last 25 years. And we've seen since 2008 unemployment almost double, from 5.5 million on the expanded definition to 11.1 million last year. And that is primarily as a result of failed government policies that drive away investment and discourage growth. And we've done many surveys of potential investors who decide not to invest or who disinvest from South Africa, and they name electricity uncertainty and race laws as the primary factor that drive away investment.
So guys, in particular, the problem that the DA has is with Section 15 of the amended Act. And basically, this is with regards to the powers given to the Minister of Employment and Labor. This power is basically to set, the Act calls it numerical targets in terms of the different or the representation in demography of the employees, right? So in certain sectors, which the DA says, you know what, it's really at a national level, it has to do with every employer who is employing 50 or more people. They need to comply to the targets, you know, set within certain, you know, groups of people, you know, qualified individuals within their, you know, companies. And this whole thing really stems from the fact that there is a feeling, right, in certain quarters that there's not much representation when it comes to executive levels in certain companies, you know, positions that matter, right? There's not much representation of designated groups. So this is where the battle is. And the DA is saying that, you know, what you're doing, you are driving away investment. You know, we are driving away investment, you know, with these, what they've termed racially based quotas. So the DA is saying that this is not about employment targets. It's not targets. Was in the past, the employers could set targets based on their own companies, right? What's happening within their company, within the context of their, industry. They could set targets and push to meet those targets. But now the DA is saying what the minister will be able to do is pretty much draconian. They're going to set these, what they're calling quotas, without the proper context of an individual company, and they're going to be subjected to heavy fines. So what I'm going to do here now is just we're going to go to the founding affidavit itself so that you can hear some of the arguments, right, in terms of why the DA in particular is saying that this amendment is unconstitutional. It is basically unconstitutional. That's what they are saying. In terms of Section 9 of the Constitution, it's unfair discrimination. It doesn't achieve any redress of the past, apartheid and all these things. And this is, in fact, taking the country backwards. So, guys, it's not this year, it's been a lot of, issues, especially with the states with regards to these, Elon Musk, spoke about, these racially, laws, quote unquote, racially discriminatory laws, talking about the triple BEE, and now it's a similar conversation. Also, not saying that the intentions of these parties are the same, but it is definitely an issue which is coming up, time and time again about, racially based laws. And you guys, let me know. I know you guys have got your different opinions whether these laws are still needed in terms of employment equity. Should they be tightened as what the amendments are seeking to do? Or should we just let this go? Because the DA is saying the way you create jobs, you provide opportunities, the way you provide redress is by creating more jobs. And these amendments are doing the exact opposite thing. You guys let me know what you think about that. John Henry Stenhazen is the leader. So let's look at, his founding affidavit. He says, I'm advised that this power is plainly unconstitutional for at least the following reasons. By way of summary, first, it is a power to set demographic quotas, which is an unconstitutional violation of Section 9 of the Constitution and contrary to the express provisions of Section 15.3 of the Employment Equity Act 55 of 1998. Second, even if it's assumed that the power is not properly characterized as a quota power, it is nevertheless a blunt and entirely disproportionate restitutory scheme that does not meet the requirements of Section 9.2 of the Constitution, which constitutes unfair discrimination. Third, the scheme violates the rights to freedom of residence and of trade, occupation, and profession. Fourth, it is a vague and unrestrained power with the potential to violate rights, falling foul of the principle in Dahoud versus Minister of Home Affairs. And finally, it was incorrectly tagged as a bill under Section 75 of the Constitution. It should have been tagged as under Section 76. So basically what they're saying is that Section 76 deals with the National Council of Provinces, right? And this bill should have gone through the NCOP instead of just going through, the National Assembly where it was put forth, because it affects provinces in a significant way, and different provinces have different, demographic setups. Looking at places like KZN and Cape Town, for example, where there are more Indians in KZN, more colors, for example, in Cape Town or in the Western Cape. So that is the sort of the summary of the challenge. But going deeper into the challenge, all right, so this is just one example, guys. It says here, for example, that the impugned scheme has the potential to create an absolute barrier to employment or advancement for members of particular racial groups in a particular area. The draft targets illustrate the point. So, for example, X, an Indian woman falling within the skilled category in the financial and insurance category sector, living in Gauteng. The draft targets applicable to designated employers operating in Gauteng would prescribe that a minimum of 82.3% of the workforce of any designated employer must be African, a minimum 2.4% must be colored, a minimum 11% must be white, and a minimum of 1.7% must be Indian men. This adds up to a collective minimum of 97.4% for all of the race and gender groups other than Indian women. Thus, an employment ceiling of 2.6% for skilled Indian women in the financial and insurance categories in Gauteng. It follows that it will become exceedingly difficult for X to find a job in Gauteng. She must find a designated employer that has not hit its very low Indian woman ceiling that needs her particular set of skills within reasonable proximity of where she lives. If she cannot do so, she must move somewhere else to find a job. But she could only really move to KwaZulu-Natal to improve her chances, given that this is the only province in which the Indian woman ceiling is higher than it is in Gauteng. In every other province, it is lower. I do not have to belabor the point that it is exceedingly arduous echo of our history for government policy to effectively require Indian people to move to KwaZulu-Natal to look for work. So, in response, so you may be wondering, what is the government saying about this? What is the Minister of Employment and Labor saying about this? So, in a communication sent out on the 5th of May, the Minister of Employment and Labor, Ms. Nomakosazana Meth, has noted with dismay the Democratic Alliance stands against transformation by challenging the amendments of the Employment Equity Act. The DA's attack on these regulations is based on the claim that the Section 15A scheme is unconstitutional. However, as stated Section 2 of the Employment Equity Act, the minister's implementation of these measures cannot legally constitute unfair discrimination. The DA's challenge seeks to disrupt efforts aimed at achieving equitable representation and maintaining an inherently unfair status quo. By opposing these amendments, the DA is actively sabotaging the transformation goals that have been pursued since the end of the apartheid era, effectively hindering progress towards equality and fairness in the workplace. This stance is not only anti-transformation, but also a step backward in the fight for equality and fairness in the workplace. So guys, there is definitely a disagreement here. That's why the issue is in court. But let me know what you think. Should there be targets in terms of representation of certain racial groups in certain positions, skilled positions, executive positions, and the likes? Let me know what you guys think about this. And yeah, will it take the country forward? Will it take it backwards? What's the story here? Let me know what you think, guys. If you enjoy this type of content, hit the like button, subscribe, and share this video with someone else. Cheers. Bye-bye.